Hey, what's up, guys? Welcome to Hate-splaining the Interwebs. I'm your substitute host, Ron Toye. I'm the sheepdog, and I will protect you from all of the meanness. But if you get out of line, I'm gonna grab that fucking remote. I'm gonna grab that remote. Think about it. Can I watch, please? Today, can I watch, please? Please. Hey, what's up, guys? Welcome. Sorry I was late. You can see I was held up by a cuckold actual. That's what we call them in the meme war. Is cuckold actual. What is my I can explain, okay? Look. Quarantine is strange times. Strange times in this quarantine land. And I figured if I was going to go out and drink with my boys and ladies, that I would shower and try and look nice. And then my shower took too long because I have too much hair, because I can't get a haircut, because the government. Okay? Okay. So... that's where we're at. That's where we at. And I am sorry. I tried to, I thought I'd have a little bit more time, but I didn't. I started showering at 7 this morning, and I just finished. Oh boy. So tonight we are going to go through Jamie Marquee's appeal. Well, not her appeal, right? Her response to the appeal. We're going to go through Jamie Marquee's response to the appeal, and we're going to go ahead and just see how that goes. I have not read it yet. I know some people out there have, and that's cool. We're going to react to it together. I mean, at this point, right? Like, I can go through and point out the good and the bad arguments that I see or whatever. But at this point, it's up to an appeals court judge panel. That's where we're at. And so the most important thing is really what's in there. Let's see what they're saying about the arguments. See if it measures up to the reality of the documents that we've seen. And just go from there. Let's see if their argument is persuasive. I don't know what happened here. It's a disaster. And we'll just take it one step at a time. Marquee's and Funimation's documents are in. Last I saw, I assume Rial and Toye's are in as well. I haven't seen anything about an extension, and I thought they might do an extension for coronavirus, although it's completely unnecessary. But, they chose to go through with it, which is great. And now we get to see how it shakes out. Who knows? Who knows? Let's, hold on. I'm getting the documents pulled up right now. As I was in the shower, it's hard to have the documents up on the desktop for the stream. I want to be able to share them with you. The other thing I will be doing in just a little bit, we'll start this. We are going to review some Bearface Triple Oak aged Canadian whiskey. 7 years. And I'm looking forward to it. Yeah, there's the response brief for Jamie Marquee. Okay, so the doesn't look like Rial and Toye's is up yet on the website. That does not mean they didn't file it. If you file it after business hours, a lot of times it'll kick over on the next day. So I'm like I said, I'm assuming they filed it and working from there. I think I heard that they uploaded it to the Shane drive already anyway. So If they did that, then they definitely filed it. But more importantly, how are you guys tonight? There's already been a lot about me. Like what I'm doing. Oh my goodness. As if I'm at all important. But how are y'all? Hopefully y'all are doing well. Weathering that quarantine. Enjoying your government appointed coof time. Because you can't coof when you are out in your essential travel, right? Everybody looks at you funny. And I swear, every time I leave my house, just a little one just comes out somewhere around people. And I feel like such a jerk. Even though it's like, there's just a thing in my throat. I don't cough ever until I see you. But, yeah. I saw there's some other drama going on out there in the Weeb Wars world. Oh, guys. The drama is legit. But, that's, I don't know what to do about it. Nothing I can. It's not my job. And there's nothing I can do about it. So, make your own decisions. Realize that over the course of a year, a lot has changed back and forth on all sorts of subjects. If you're seeing leaked DMs from a year ago, I mean, you have to judge what they're worth on your own. Okay. But that's up to y'all. And you guys you guys have been doing this for a year too. You make your own decisions. So, there we go. As for me, I'm going to have some Canadian whiskey in just a second. My fault for being team leader. I'm not team leader. This is just like my last job all over again. All the responsibilities on your shoulders. Do I have any actual authority over people? No. Wait. So I can't tell them to do their work, but if they don't get their work done, it's my fault? Yes. I don't like this job. Okay, hold on. We got to do a proper review of this whiskey. Now, if you don't know how I do these whiskey reviews, we do them in a couple steps. Because you can't do it. The first step is simple. It's a simple sip test of whiskey. Take a sip. You let it breathe. You let it hang out in your mouth a little bit. You swallow it. You let that breath come back up through your throat and nostrils. And you just measure all of that stuff, okay? So we're going to do that first. It's an obnoxious and pretentious process. But if you're not familiar with the whiskey, always start with this. You'll thank me. I did show the bottle. It's Bearface. Right here. Bearface, 7-year, triple oak, triple... Oh, that's just the French, because it's got to be in French. It says, hide nothing, fear nothing. So, whatever. But this came highly recommended from someone up in Kitchener. And they brought me the bottle. I was very appreciative of that. Okay. Kind of smell the oaky smell to this. I don't know what that even means, but it's true. Very clean and clear. It's crisp. It's not a strong, acrid, alcoholic smell. Like some people. Oh, yeah. Yeah. That is really smooth. Goes in your mouth. There's no burn at all. Not a shred. Very good. I mean, it's whiskey, right? At the end of the day, it's whiskey. there are not a lot of flavor differences from whiskey to whiskey. There's a lot of quality difference that you can taste. This is a very smooth whiskey. There's no bite to it at all. That's what we call a dangerous drink. There's nothing on the breathe. After you drink it, breathe it out. It's nothing. It's weird. That's a strange thing. Normally there's some flavor or aroma that comes out. Very clean. Nothing going on. I'm not sure how much I like that, because I like to have that last hit of flavor, because it's usually different. This one is, it's empty. That's cool. Yeah, very, very good whiskey. I would recommend this. Well, 100%. This is better than a lot of my latest endeavors. So, very, very good. I will, in a little while, I'll do the shot test. We'll do that in a little bit. And that's where I just take a shot of it and see how that goes. So, extra scruffy. Look, if I can't get my hair cut, I'm not gonna shave. Cause then I'd have like a trim down here, but then long shaggy stuff up there. That was good stuff. Yeah, wild turkey is good, but it's nothing like that. All right. Shill the GoFundMe, please. That's a good idea. We haven't done that in a while. Let's see. Whoops, if I could type. All right, guys. Here we are. Man, this has been... It's always... Son of a hooker. Nothing you guys did. It's everything that Windows just did to me. All right. It's been a year. It's been over a year, obviously. But it has been also a year. And I was explaining to Q. All right, let's do it this way. I was explaining to Q because, as you know, I had Q on the show yesterday. And just a little bit ago... yesterday prior to coming on the show, Q made a joke about Greg Doucette not liking black people because he was blocked. And so is his brother, even though they've never interacted with him. Now, I, of course, have explained since that Greg Doucette is very brave and stunning, a very stunning and brave woman, and uses a block bot software to go ahead and block the followers of me because he doesn't like the fact that he gets ratioed, because his interaction on his tweets is so damn low that if he posts something and gets like 12 likes, but then even a very few amount of people decide to chime in, he gets ratioed into the dirt with responses. And it just doesn't look good, right? If you have 12 likes and 100 replies or whatever. So he does the block bot thing, which is fine. I mean, he can do that. I don't care. So Q makes a joke. Well, some T-Greg orbiters came out and have been relentlessly going after Q now on Twitter, right? And he's started a firestorm of this thing. And he calls me up and he's like, "Hey man, I'm sorry. I was just having some fun. I didn't want to start any controversy or anything." And I was like, "Don't worry about it. Because if it wasn't you, they'd just be doing it anyway. Because it's the same small group of people who have done this involving me every day for over a year." He's like, "Every day?" Yes. Every single day. If I make a post, one of these bored delightful people will go on and try and stir up something on every tweet. Every one. So I don't, and so I said, "Don't worry about it. I don't care. Like, let them just crow. Who cares? It's Twitter. Doesn't really matter." But yeah, they just and so I had to explain to it. That is a good summary for this, man. It has been a year, and sometimes every day feels really long. And so I know I haven't been doing a lot of Vic coverage lately, and I haven't done the GoFundMe a lot lately because I've been getting some feedback. I'm feeling it. I know other people are feeling it too. There's burnout when you've talked about something so much over the past year. And there has been a big slowdown in the case. We're talking about it now because we do have documents to go through. And other than that, you know, I try and avoid it. Now, the Ronversations are unavoidable because when Ron starts chattering, you know, I'll answer him and talk to him as long as he wants to talk. Of course, I'm a gentleman. I'm not gonna ignore him. So that's their own thing. But as far as the case goes, this is just where we are. It's been a long time, and I know a lot of people are kind of burnt out on it. And so I've been trying to measure that out and break it up with other stuff, of course. So here we are, though. We are at $277,250. Let me just make sure. Yep, and we've got the ledest donation from Gelth Walker. Thank you to Gelth. Thank you to Amanda Marie, Anonymous, Pedro Morales, Aaron Rogers, Malik Foxon. I'm Nick Rekieta, and I support Adblock. Okay, I think that one came in while I was on air the other day. Rude, by the way. So you're on Akinator, and it got you correct after just 35. I don't even know what that is. I have no idea. But yes, so that's where the GoFundMe is, $277,250. As tradition demands, if the GoFundMe is brought up at all in the appeals, it will be brought up on the stream, right? If we have a GoFundMe in the document, we're going to have a GoFundMe pop up on the stream. I assume it's going to be in there at least at some point. Oh, and some of you may ask, like, why, Nick, why would you choose Jamie Marquee first? Well, oddly enough, I expect Sam Johnson to put up the most competent document. So that's why we're going with it first. Sam, I believe, will put up the most competent document. I expect Lemoyne, I expect Wick Phillips' document to be the least competent, so we'll do that one last. And I expect, you know, Volney to be somewhere in the middle. And so we'll do that one. We'll do that one next. But now that's like 3-4 shows or whatever, depending on how long these all take. I am not going to do them straight in a row. We'll probably do one tonight, one tomorrow, maybe, or the next day. I'm trying to get Papa Ethan Van Sciver on to talk about Cyberfrog Wrecked Planet, to talk about the meltdown in the comics industry in regards to distribution, in regards to the comic pros coming out and having issues with getting payments to people and all of that stuff. And so we will hopefully I'll be able to get Ethan on this week to talk about stuff and to break this stuff up. There are also maybe other guests coming on, kind of working on lining some things up. But needless to say, we're not going to have 4 straight days of appeals documents because, trust me, after reading one, you're going to be finding the bridge and contemplating your life. So 3 in a row, not sure we want to do it. And you know Wick Phillips is, well, actually, you probably do know how much Wick Phillips's document is. I don't, but I assume it's ridiculous. This one is 45 pages. It's relatively lean. I think it's 39 pages of actual legal stuff once you get past the table of contents and all that junk. And yeah, so that's where we're at, and we're going to hit it in just a second. Couple quick things, couple super chats, and then we'll go. All right. First thing, Mr. Peacock has a channel. It's been a long time coming. It's here. His first video is him reading. It's a H.P. Lovecraft short story. Go check it out. And next thing about that is I've heard the audio is not solid. Look, when you're first starting out in this thing, one of the hardest things to do is lock down the audio. And he's mentioned to me that he's getting another mic and working on the audio issues, but ignore the audio for the first video. Go listen to it. I love the look and feel of it. He's sitting there in a robe reading. It's very, very like Masterpiece. What was it? What was that show where guy would just sit in like a big leather armchair and read children's stories or whatever? It's great. It's great. Plus, he's fantastic, of course. So go give him some love. Also, if you're not aware, this show is brought to you today by my Rekieta Media channel, which is the alternate channel, Rekieta Media. The link should be somewhere, like in the description or whatever. Otherwise, you can find Rekieta Media. And I have posted, as of last night or early this morning, the first video on the Rekieta Media channel, which is my review of the special edition of Horus Rising. So you can check that out if you're into geeky, nerdy stuff. That's a place where there will be some. And I'm working on producing content. It's in a completely different environment than the vault. It's on my kitchen table. And working on the sound up there as well is also challenging. So I think it sounds pretty good, though. Pretty good. So please give that a look. If you like it, guys, you could really help me out by sharing that around, by letting people know about it. It makes all the difference in the world. Many of you have already watched it, and thank you so much for that. All right. Now, couple super chats, and then we're golden. BTL Video Production says, late gay boy trash is questionable. Come on. Siren Jag says, thank you for choosing your local Donner Pass Whole Foods. Look for our specials in the meat department. Our quality meats are locally sourced from right here in the Sierra Nevadas, raised without antibiotics, and guaranteed fresh cut. Gross. Gross. Anonym says, Moscow is about to go full 1984 with personalized QR tags required for leaving your home. This might be my last message. Keep the VIX poster, boomer. God bless. Oh, no. No. I'm still sending it. Random Blaze says, Manjaw is so emboldened that it is now going after Bezos and Biden. Low T Shill thinks that you can yell fire in a theater with no fire and not be sued. I can't wait for this to actually hit appeals. Grift harder, Nikki. Okay. All right. Well, here we go. Anderil 420 says 1981 Dean Koontz, The Eyes of Darkness, talks about in 2020 the coronavirus showing up, disappearing, then 10 years later reappearing. No, it doesn't. Really? I don't think I read The Eyes of Darkness. Now I will. I think I have it. Lady Raggett has a bunch of Dean Koontz books. Although most of them I think she got from my dad. So we'll check it out. Okay, here's this appeal document for Jamie Marquee. So we've got the index of authorities. We're going to skip that. Statement, we'll read all of this stuff. The index of authorities is just all of the citations they have, and then the page numbers where they're referenced. So nothing, we've got some of the expected citations, right? We've got, they're in alphabetical order. We've got Lipsky. We've seen a lot of Lipsky. We've got, of course, New York Times versus Sullivan. We've got Vanderlinden versus Kahn as well. Interestingly, they don't bring up Lane versus Ferris or whatever. I think it was Lane versus Ferris. Lane? The one they've used for the public figure argument quite a bit, but we'll see. We'll see what goes. Statement regarding oral argument. Appellee does not believe that oral argument would be necessary or helpful for the determination of this appeal. She doesn't want to pay for it. If the court grants appellant's request for oral argument as to appellee respectfully requests the opportunity to present and participate in such oral argument. So they have Vic's team requested oral argument. These guys have requested there not be oral argument. I believe Funimation's team has requested oral argument as well. Statement of facts. So here we go with that. Russian Bot says, hey, what is the Stafford Act? I heard something might be going down involving it. You know, just 1 second. I've seen it. Oh, this is a disaster relief thing back in the 80s. I don't actually know. I'm not boned up on the Stafford Act, but it probably has something to do with how they're conducting the disaster relief right now. I couldn't tell you right now. But all right, so here's the statement of facts. The anime industry. Appellee Jamie Marquee is a voice actor, actress, and writer. Is she man? Who primarily works in the anime industry. Okay, so we've got citations, or just to the record. Term anime refers to hand-drawn and or computer animation originating from or associated with Japan. They didn't lay foundation. I'm just kidding. Appellant Victor Mignogna is one of the most ubiquitous voice actors in the anime genre, credited with over 356 productions on the Internet Movie Database. He also voiced the title character in Dragon Ball Super Broly, the third highest grossing anime film of all time in the United States. So what they're immediately trying to do here is bone up the public figure argument. The interesting thing, of course, being that they just had to explain to the judges what anime even was. And now they're saying he's super famous in anime. So it's, again, not going to help out on a general purpose public figure argument. They're going to still have to argue that limited purpose public figure. But, you know, the Chup gave it to him. Indeed, appellate can hardly walk into an anime convention without being immediately recognized. Oh, man. Appellate's assault on appellee Marchi. In approximately 2011, appellee Marchi worked as a voice actor for appellee Funimation Productions, LLC. On one occasion, don't know when, while at Funimation's headquarters in Flower Mound, Texas, appellee Marchi was waiting in the lobby when appellant approached her. Considering that they knew each other and that it is a common greeting among creatives in the anime industry, appellee Marchi gave appellant a hug. What appellee Marchi did not and could not anticipate was what happened next. Commenting on appellee Marchi's hair, appellant began running his hand through the back of appellee Marchi's hair until his palm found the back of her skull. Appellant splayed his fingers and moved his hand to the base of appellee Marchi's skull. Okay. Now, I'm not going to criticize the writing of Sam Johnson here. If his palm found the back of her skull, why would he have to splay his fingers and move his hand to the base of her skull? Okay, after which he clenched his hand into a fist, grabbing her hair at the roots and jerked his fist, yanking appellee Marchi's head backwards. Having control of appellee Marchi, appellant then pressed his lips to her ear and whispered something sexual to her. Appellee Marchi doesn't remember the specific words appellant spewed at her that day. Sam, if you're whispering something into someone's ear with your lips, you're not spewing. Just minor technical criticisms of your syntax and usage. It is hard to spew something with a whisper of something sexual into their ear. But she very much recalls the way she felt violated, out of control, and intimidated. I don't think so. I don't think she recalls that at all. Because I don't believe this ever happened. Not in that way, but fine. At all times during appellant's assault on appellee Marchi, she did not consent to nor want such contact as was imposed upon her by appellant. Shocked and stunned by what appellant had done to her, appellee Marchi never felt safe at Funimation again when appellant was around. Really? Oh, that's bullshit. I mean, that's just bullshit. Obviously, considering that appellant was one of the most ubiquitous voice actors on the convention circuit, appellee Marchi felt that nobody would even believe her if she told her story, let alone have her career survive. Like countless victims before her, she kept her story to herself as a means of protecting herself from retribution or worse, further trauma. Now, why would she expect retribution? Who in the anime industry was protecting Vic? I mean, they didn't do it this time. So where is she fearing it from? These are, of course, the questions that we need to ask, not from a legal standpoint. I mean, from a legal standpoint, Vic says this didn't happen. So at the TCPA stage, it's supposed to have not happened. It's false. He says it's false. This is the problem, right? And again, this is the problem with Chup's decision. That being said, from a non-legal standpoint, from a common sense standpoint, who is she afraid of? Presumably not Vic, because Vic obviously had no control. Not even apparent authority over her at the time or any time after. He's never been in a position to hire or fire or otherwise deal with Jamie Marquee. But she's scared of somebody in anime, and that's my point. She is scared of somebody in anime. Who's she scared of? Why haven't they gone after that person? The people who would leap up to protect a ubiquitous voice actor in the face of such horrific sexual assault. Who are they scared of? The truth about appellant. Ooh. Rumors about appellant. The truth. Rumors. Again, this is a bad dichotomy from a usage point. If you're writing a persuasive paper, I wouldn't start my subheading with the truth and then start the paragraph that follows the subheading with rumors. Rumors about appellant had swirled in anime circles for years before appellee Marquee's 2011 encounter with him, so much so that appellant held a rumor panel at an anime convention years ago to address the various rumors plaguing him from much of his career. Much of his career, plaguing him is a weird term because, I mean, sure, they're there. They didn't plague his career at all. They didn't harm his career in any way. And they're going to now state that he basically said they were all false and has always maintained that they're false. So that's an interesting tactic. Malik Foxon says, we're taking a trip back to shit that never happened, land again, as Shuon Head would put it. You think Sam and Marquee thought up that writing together? Sounds exactly like some fanfic. Well, Jamie she's a very accomplished writer at Funimation. At the beginning of 2019, appellant's victims started speaking out about the pain. Wait, if there were rumors for years, how did they start speaking out in 2019? About the pain appellant had wrought upon them. Seeing that, that's not actually a true statement. That's weird. Seeing the hatred and shame appellant's followers attempted to hurl at appellant's victim online, appellee Marquee could no longer stay silent. On February 8th, appellee Marquee bravely told the true story of her encounter with appellant so many years before. This is an interesting tactic for Sam and Marquee to take. Here she is, admitting that this is her story as part of the record. Like, here they are. They're saying, this is what she did on this date Here it is in the record. If Vic holds this is false, I mean, they didn't say it's not in the record. Several years ago, I was in the lobby at my job. When I was approached by a coworker, this guy gave me the creeps already. He gave almost all the women at my job the creeps. Also not true. But I always felt like I had to be nice to him anyway because of how revered he was in the industry. We hug a lot, and on occasion, we'll give a kiss on the cheek. But even for an affectionate environment, this felt off. I didn't say anything to him about it, though. It was just his fingers in my hair. I didn't think it was a big deal. At that point, he splayed his fingers, put his hands at the base of my skull, and made a fist. When he did this, he grabbed my hair close to the root, effectively preventing me from moving my head at all. He then jerked his fist, yanking my head backwards and towards him, and whispered something in my ear. I don't remember what he said specifically, but I do remember it being sexual in nature. This was not normal. This was not just a hug or a kiss on the cheek. I did not like it. I have no memory of getting out of his grasp, but I assume, what the fuck are you doing, was part of my technique. Sure it was. Of course it was. Except it wasn't. It's not a true story. Mithrin Emra says, sounds to me like Sam is using his facts section to assert the truth of the defamatory statements. That is a determination for the fact finder at trial, not during a TCPA hearing where the plaintiff's claims are taken as true. I know. It's a weird decision to make. He should. I mean, I guess they're going to argue that this isn't in the record. I guess. Very strange. Appellant starts a new assault. On March 8th, 2019, appellee Marchi received from appellant a demand that she preserve all electronically stored information and other information relevant to the claims and defenses asserted in this matter. Yeah, we're going to sue you. Litigation notice. Ironically, appellant himself allegedly has a policy of immediately deleting his own electronically stored information and has done so even after anticipating litigation in this matter, and also swapped his old iPhone out for a new one just as litigation in the trial was getting started. Less than a month later, appellant sent appellee Marchi correspondence asking her to correct, clarify, or retract some of her tweets. Notice they didn't. This actually is pretty interesting because they never dealt with this at a hearing. Right? Like that's part of the issue. I'm not sure that this is in the record. I mean, they're citing to the record. I suppose I could find it. But the interesting thing is they didn't resolve this matter at the lower courts. They could have. They could have pressed Judge Chupp to do something about it, but they didn't. So, here we go. Less than a month later, appellate sent appellee Marchi correspondence asking her to correct, clarify, or retract some of her tweets. That's a TDMA letter. Many of the statements complained of by appellant in his April 12, 2019 takedown letter to appellee Marchi neither refer to appellant nor contain any statements of fact, nor even rise to the level of an actionable publication. You know what's interesting about this? They didn't make a motion stating that the TDMA was invalid, which is what is required in the statute. They didn't address this at the trial court level. All of them should have, but they didn't. Why? Not one defendant made a motion challenging the sufficiency of the TDMA letters. Not one. Casey Eric put it in his answer, but he didn't file a motion on it. They didn't do it. So they're going to raise the specter of illegitimacy of the TDMA letters, but they forfeited that argument. I would point that out to the trial or to the appellate court, that they're going after things that they refuse to bring in the lower court. They're trying to raise new issues at appeals to cloud the appellate decision. I'd raise that immediately. All right. Here we go. We're going to do the shot here. When you do a full shot, it's got a little burn. A little burn. Not much. Very surprising. It's really a neutral whiskey in general. Smooth, flavors are muted. I mean, there's a nice distinct whiskey taste to it. It's not bad. It's not sour at all. Man, you could drink it like really, really easy. Whew. While some of the cited tweets admittedly contain strongly worded opinion commentary, this is not opinion commentary. This is facts. These are facts. They're alleging this to be true facts stated. It's not opinion commentary. None are false statements of fact made by appellant with knowledge of their falsity or reckless disregard of whether or not they were true. Let's see. I was in the lobby at my job when I was approached by a coworker. Is that a false statement of fact? That's certainly a statement of fact. This guy gave me the creeps already. Gave almost all the women at my job the creeps. These are opinion statements. But I always felt like I had to be nice to him because of how he was revered in the industry. Opinion. We hug a lot, and on occasion we'll give a kiss on the cheek. Fact. But even for an affectionate environment, this felt off. Opinion. I didn't say anything to him about it, though. Fact. It was just his fingers in my hair. Opinion. I didn't think it was a big deal. Opinion. At that point, he splayed his fingers, put his hand at the base of my skull, and made a fist. That's a fucking fact. That's not an opinion. If someone has their hand on your skull, they splay their fingers and make a fist grabbing you by the short and curlies, that's not an opinion. There is no way in shit you can argue that someone grabbing your hair with their hand and tugging on it is an opinion. That's a statement of fact. When he did this, he grabbed my hair close to the root. Statement of fact. Effectively preventing me from moving my head at all. Statement of fact. That's not an opinion. He then jerked his fist, yanking my head backwards and towards him, and whispered something in my ear. Statement of fact. I don't remember what he said specifically, but I do remember it being sexual in nature. That's a statement of fact too. That's a statement of fact as well. This was not normal. Opinion. This was not just a hug or a kiss on the cheek. Opinion. I did not like it. Opinion. I have no memory of getting out of his grasp, but I assume what the fuck are you doing was part of my technique is opinion. There are definitely statements of fact in there. Brazen to outright claim that there's not statements of fact in there. Because, I mean, they're right there. They're right in the text that you just cited. How are you going to argue that those are not fact statements? Andrew Bin says Vic didn't whisper something sexual. He merely asked her if she wanted to go to Flavor Town. Oh, no. Okay, anyway, back to this. Strongly worded opinion commentary. Certainly none were made with malice, only the intent to protect herself and others. That's not malice that we're worried about. It's actual malice that we're worried about. Knowledge of the falsity. If none of that happened, she made those statements knowing that they didn't happen. That's an interesting part of Vanderlinden versus Kahn. Is if you experience it, you obviously know whether or not it happened. The sole statement by appellee Marchi that contains any statement of fact referring to the appellant is that is susceptible to truth or falsity was born of her need to tell the truth about what appellant did to her. Okay, so are they saying that they're admitting that there are statements of fact here? They're just true? Okay, good job. TCPA, that doesn't really matter what you say is true. If you say it's true and the other guy says it's not true, then it's not true. You got to go to trial for that. Appellants admit under oath to assaulting appellee Marchi. Appellant filed his original petition on April 18th, 2019, making almost no reference to appellee Marchi. Indeed, appellant cited only appellee Marchi's February 8th, 2019 tweet and a couple of tweet replies, neither of which reference appellant nor make any statement of fact, defamatory or otherwise. While sworn under oath in his deposition, appellant plainly admitted to assaulting appellant in exactly the same manner as described by appellee Marchi in her statement. And I'm like, oh my gosh, I love your hair. And she's like, I know. This is exactly the same. Exactly the same manner is what we're going to go with here. And I'm like, oh my gosh, I love your hair. And she's like, I know. I just got it. And I walked around the counter and I was kind of standing there, kind of flipping it and like, oh my gosh, it's really beautiful. I love it. And I put my hand up in the bottom of it and I'm like, oh, this is great. The bottom of your hair, not the base of your skull. Bottom of your hair. Those are two different things, Sam. Though the camera veered slightly to the right just before, appellant gestured on camera about the tight grasp he had over appellee Marchi. This is a fucking lie, and Sam knows it. This statement is an absolute travesty. Because that's just a lie right to the court. Wow. Wow. Mithrin Emrys, appellate judge. Mr. Johnson, can you explain what part of he grabbed my hair is an opinion? Is the verb grabbed? Should that be tugged or yanked? Does opinion rest on the choice of verb? Appellant then had the audacity to interpret how he thought appellee Marchi should have felt. No, that's not audacious, by the way. It was not painful, it was not hurtful, it was not sexual, and it happened at least 4 or 5 years ago, maybe longer. This is directly contradicting the story that he said was exactly the same. I mean, right there. Right there. Nevertheless, appellant admits that individuals can perceive the same situation differently, and that Ms. Marchi could have perceived her hair being pulled differently than appellant did. Doesn't make it true. Also doesn't make a fact an opinion. That's the interesting thing about that. If you say he grabbed my hair and he says, I didn't grab her hair, I touched her hair. Those are two different things. Could she have perceived it differently? Yeah, but she said I grabbed her hair and I didn't. Appellant attempts to skirt the parties' Rule 11 agreement. Oh, here we go. Appellant gave his deposition on June 26, 2019, but he never requested appellee Marchi's deposition, even though he did depose appellees Rial and Toye. After Marchi filed her motion to dismiss pursuant to the TCPA on July 19th, appellant on July 29th, 2019 requested a continuance of the initial August 8th, 2019 hearing on the same. Though such request was initially opposed, the parties ultimately agreed to reset the hearing in consideration of their mutual agreement to certain deadlines set forth in the Rule 11 agreement and filed with the trial court. Allegedly due to technical difficulties, appellant missed his August 30th deadline to file his response. Just after midnight on August 31st, appellant filed his response to defendant's TCPA motion to dismiss. Other than by virtue of attaching the entirety of appellant's deposition transcript and exhibit thereto, appellant proffered no evidence whatsoever that referred to appellee Marchi or addressed appellant's claims against her. On the same day, appellee Marchi's reply to appellant's response was due, September 3rd, 2019, and only 3 days before the hearing on appellee's TCPA motions. Appellant filed a second amended petition, attaching to it hundreds of new pages of alleged evidence. They weren't new. Actually, most of it was a condensed version of the 1,000 pages of transcripts that was included. So that was the bulk of what was attached to it. The other things that were attached were the affidavits, the unsworn declarations that were replacing the affidavits, and a supplement thereto with additional alleged evidence. Appellant also withdrew the affidavits attached to his response after appellees Marchi, Rial, and Toye complained about the fraudulent nature in which they were obtained. That's interesting, because they weren't fraudulently obtained, they're improperly notarized. Appellant was attempting to subvert the parties' Rule 11 agreement, not true. TCPA, nope. And the Texas Rules of Civil Procedure, nope. In an unfair and impermissible effort to sneak new evidence into the record at the 11th hour. This is a bad course of argument for one specific reason. if there's evidence in a TCPA that would make the case hearable, the TCPA would want that evidence included. Appellee Marquee and the other appellees objected immediately. Again, if your argument is we shouldn't have to go through this because of a technical rule preventing the good evidence, it's not the most effective argumentative tactic. If there's evidence that supports what's the prima facie case, there's a strong argument that it should be included. The trial court rules. Appellees and their counsel, as well as appellant's counsel, all appeared for hearing on appellees' respective TCPA motions on September 6, 2019. So compelling was appellant's inability to present clear and specific evidence setting up a prima facie case for his claims against appellee Marchi. The trial court dismissed all of appellant's claims against her and then and there at the hearing. The trial court further clarified in its order dismissing the claims against Marchi that it rightfully did not consider the late filed alleged evidence attempted to be utilized by appellant, and that appellant had failed to establish by clear and specific evidence a prima facie case for each element of his claims against appellee Marchi. And then we have a giant blank space. Not sure why that's there. Very strange. Oh, I guess that's just the facts section in general. So now we're moving to the summary section. That's not so strange. Never mind. Okay. Yeah, so we know how the trial court hearing went. This is, of course, this paragraph is describing the nature of the problems with the hearing that they're already appealing on. So, summary of the argument. Oh, man. Just a moment. Whew. We're cooking through these pages. As to all appellees, but especially as to Marchi, the law and facts of this case have quite simply never fallen in favor of appellant or his ill-conceived claims. The record before this court shows just what the record in the trial court did: an absence of facts to establish by clear and specific evidence a prima facie case for each essential element of each of appellant's claims. Appellant's brief ignores Marchi nearly as much as appellant's filings in the trial court did. With a record of half facts and a brief full of misunderstood legal conclusions in the few places where appellant did take time to cite to jurisprudence, appellant cannot and does not put before this court any ground to walk back any of the findings or rulings of the trial court below. This Court of Appeals must affirm the trial court's rulings in final order. That's a summary of their argument. So now here's the full girth of the argument is coming. The TCPA exists to encourage and safeguard the constitutional rights of persons to speak freely, associate freely, to the maximum extent permitted by law. It protects citizens who speak on matters of public concern from retaliatory lawsuits that seek to intimidate or silence them. The two-step process of there has never been an attempt to intimidate or silence any of these people through a lawsuit. In fact, at any point where silence was possible, Vic has not gone to, or not even remotely possible, we should say. Vic has not attempted to do so. He never asked for an injunction. He never asked to enjoin the defendants from talking about him or saying further defamatory things. Never once has he attempted to stop their speech. He's only asked for compensation for the damage that they did to his career. The two-step process of the TCPA is initiated when the defendant files a motion to dismiss the claims against them. Initially, the burden lies with the defendant movement to show by a preponderance of the evidence that the plaintiff's claim is based on, relates to, or is in response to the movement's exercise of the right of free speech or the right of association. Once the movement does so, the second step shifts the burden to the plaintiff to establish by clear and specific evidence a prima facie case for each essential element of the claims in question. Great. Appellant does not raise a point of error as to the trial court's finding that the TCPA applies to his claims or that he is a public figure. I feel like they did this, but maybe they didn't. But I I feel like there was argument about Chup not even entertaining the public figure argument and not making a proper assessment, but maybe I don't remember that correctly. Maybe that's just what I would put into it. And thus waived any argument to the contrary. The only points of error regarding Marchi then allege that dismissal under the TCPA and the mandatory of attorneys' fees and sanctions that flowed from such dismissal were improper. Because appellant failed in the trial court to provide or point to clear and specific evidence establishing a prima facie case for each element of his claims against Marchi and fails again to do so in his briefing to this court, the trial court's dismissals must be affirmed. Sakaki Onsai says, yes, Nick, we're talking about the full girth, and if you've seen Jamie Marquee as of recent, you'll notice that girth is a very apt word to use. In fact, she's likely giving Catherine 2 tons a run for her cinnamon roll. Well, that would be helpful. That would be helpful. If they had to run for the cinnamon roll. That's what I'm saying would be helpful. All right. Issue number 1. The trial court's dismissal of appellant's claim for defamation against Marchi is not reversible error. Appellant wholly failed to establish, by clear and specific evidence, a prima facie case for each essential element of his defamation claim against appellee Marchi. In order to meet his burden, appellant was obliged to put forth clear and specific evidence that Marchi published a statement of fact. We've got that. You admitted to it earlier. The statement referred to appellant, which you admitted as well, in the facts section right here. The statement was defamatory. Since he brought up that statement and you admit that he brought up that statement in his petition, pretty sure that one's defamatory. The statement was false. He's suing because he thinks it's true. That's clearly what's going on here. And with regard to the truth of the statement, appellee Marchi acted with actual malice, and the statement caused appellant pecuniary injury. Again, all of that's in the actual brief, the petition, and you admitted to it earlier. So hopefully in their response, they'll point this out very specifically, that not only did the appellant do this at the trial court level, but appellee admits that this was done in the facts section of the case, admits to the publishing of the statement, admits that it was about the plaintiff, and merely attests that they were true statements, whereas the appellant has said over and over that they were false. So, you know, I don't know. Hopefully they do that. Appellant cites to specific excerpts from only 3 tweets by appellee Marchi in his brief, which are attached to various appellee's TCPA motions, not to appellant's response. The first, which is also, it's in the record still. The first is an undated tweet in which appellee Marchi refers to appellant as a bad person without any context. Second is a tweet dated February 7th, 2019, in which appellee Marchi speaks generically about her feelings and opinions without naming the appellant. Third is a tweet in which the appellee Marchi describes what appellant did to her. There it is again. There it is again. Statement of fact about appellant. For a statement to be actionable, it must expressly or impliedly assert facts that are objectively verifiable. Like, his fingers ran up into my hair. He grabbed he found the base of my skull, clenched his fingers, jerked his hand towards me. Those are objectively verifiable. Appellant does not explain how or why a reasonable fact finder would conclude that either the undated tweet or the February 7th tweet contain assertions of fact. He also misrepresents the nature and context of some of appellee Marchi's statements in the February 8th tweet. This is a trial court argument for a jury. That's a fact question. He's laying out right now this is a fact question. Look, he's misinterpreting the nature and context of the facts asserted. He's disagreeing with my client. Okay. The generic reference in the undated tweet to appellant being a bad person is not a statement of fact. An appellant even admitted in his deposition that the statement doesn't carry an implication that he's a criminal. Appellants also doesn't point to any evidence establishing whether or not the concept that he is a bad person is objectively verifiable. Such a statement, though, certainly reeks of subjectivity. Yeah, I agree. As a matter of law, the undated tweet cannot be said to contain a statement of fact, and appellant has not met his burden to show otherwise. Appellant expressly admits that the February 7th tweet does not contain a statement of fact and that the tweet doesn't reference appellant. As a matter of law, the February 7th tweet cannot be said to contain a statement of fact, and appellant again has not met his burden to show otherwise. Though appellant quotes appellee March in the February 8th tweet as having stated that appellant had done this exact thing for a half a dozen other women that appellant Marchi personally knows and that he is a predator, the statements are not statements of fact when viewed in context. Wait. Why are you doing this, Sam? Why would you make this argument now? You're arguing over the fact. Why would you even add this in? Okay. Appellee Marquee stated that she heard accounts of him doing this exact same thing to half a dozen other women that she personally knew. This is a statement of fact. By the way, whether or not she heard this is in Vanderlinden versus Khan. He said to me, whether or not they said it was the fact statement there. Interestingly, this is a fact statement because whether or not she heard it is objectively verifiable. Appellee Marquee didn't state that he had done this exact thing to other women, only that she had heard that he had and therefore did not make a statement of fact about the appellant. That's not true. She actually did make a statement of fact. She stated that she heard it. Similarly, appellant misstates the nature of Appellee Marquee's use of the word predator. Appellee Marquee's tweet ends with a message to anyone who ever goes through a similar experience and is a cautionary tale to anyone who finds themselves in an uncomfortable situation similar to what she experienced. It does not make reference to appellant or what he did to Appellee Marquee, nor is it asserted as a statement of fact. Again, you're arguing context. You're making a fact argument in your thing right now. With regard to these excerpts from the February 8th tweet, Appellee Marquee did not make a statement of fact referring to appellant. Not defamatory. Oh, I mean, okay. What about the actual fact statements that are in there that are plainly obvious? This is a weird course for them to take, in my opinion. A statement has a defamatory meaning only if its meaning is unambiguous in the minds of ordinary readers, without reference to any meaning attributed to it by the plaintiff or defendant. Okay, so a statement has a defamatory meaning only if its meaning is unambiguous in the minds of ordinary readers, without reference to any meaning attributed to it by the plaintiff or defendant. Okay. Appellant's only explanation regarding the alleged defamatory nature of Appellee Marquee's tweets is that falsely accusing someone of a crime or of engaging in serious sexual misconduct is defamation per se. It is. None of Appellee Marquee's tweets fit into either category. Look, if you say that someone is sexually harassing you at work by whispering something sexual into your ear, I mean, that they're a predator, you're accusing them of sexual misconduct. A defamation per se claim, such as the one appellant asserts, mandates the examining court to review the entire publication before it can determine whether a statement is actionable defamation. Appellant has failed to provide the entire context of Appellee Marquee's statement of which he complains. Sounds like a fact question. Without... that's actually... This is an interesting... I'll have to go back and read this decision because that's an interesting statement here. Appellant, I wonder if this was TCPA. Give me just 1 second. Give me 1 second here. Oh my goodness. Okay, hold on. I wasn't going to look up anything, but this is interesting. Bilbray versus Williams. I just want to see if this is a TCPA appeal or if this is an appeal on something else. Let's see. Oh, so this is an appeal under the TCPA. Interlocutory appeal from the trial court's denial of their motions to dismiss. The suit arose. Okay, well, I'll have to go through and read this later. If it wasn't from TCPA, I was going to make fun of it immediately, but I'll have to wait and actually read it. All right. Anyway, appellant has failed to provide the entire context. Without such context, there's no basis for the trial court or this court to conclude that such statements were defamatory per se. Due to its subjective nature, Jamie Marquee's statement in the undated tweet that appellant is a bad person can only be ambiguous. What one person considers bad in any given context may well be neutral to another and even acceptable to yet another person. I agree. Bad person's an opinion anyway. Being a bad person connotes neither criminality nor serious sexual misconduct. By citing to a tweet response without the tweet being responded to, appellant has failed to show the court the full context in which the statement was made in the first place. Because appellant did not brief for this court why the tweet was allegedly defamatory, it's impossible to understand what he alleges to be the clear and specific evidence of the same. This tweet isn't that important in my opinion. Statements in the February 7th tweet contain absolutely no context to explain why Jamie Marquee was upset with whomever she was writing about, and don't even contemplate touching on criminality or serious sexual misconduct. She could just as easily have been distraught over a bad loss at Scrabble. I mean, come on. This is one of those, look, we don't know, but we know, but we don't know, though. As over having her hair yanked down and control of her own body taken from her. Again, appellant has failed to show this court the context of which the February 7th tweet was made. Quite simply is not shown how this particular tweet was capable of defamatory meaning, likely because it was not. Neither did appellant brief for this court how any statement in the February 8th tweet is allegedly defamatory. Really? Though Jamie Marquee does state her recollection that appellant whispered something sexual to her, she never accuses appellant of serious sexual misconduct. Does not even imply that he engaged in same. Really? Appellant also hasn't stated where in the tweet Jamie Marquee falsely accused him of a crime recognized under Texas or federal law, because she doesn't. Well, I mean, except that you know that would be a battery. An unwanted touch is a battery. Absolutely. Indeed, appellant testified that he doesn't even know if any crime in the Texas Penal Code results in classification as a predator. No, he doesn't, because he's not a lawyer or a judge or a cop or anybody who should know. Spoiler alert, none do. Appellant is unable to explain to the court, just as he was unable to do in the trial court, how the February 8th tweet is defamatory under Texas law, which is why appellant has not even attempted to do so in his brief in this court. All kidding aside, they should really shore up in their response to this and hammer on just exactly what's defamatory in that long tweet. And there's a lot that's defamatory. And Sam admitted it. It's in the record. It's right there. So they should just go ahead and highlight what's defamatory. That Vic has denied all of this stuff. He denied the grasping of the hair. He denied all of that stuff, and that they misrepresented his own statements from the deposition in this document. Falsity. Appellant bears the burden of proving that Marquee's statements is false. No, not at the TCPA. Not at all, actually. They bear the burden of showing that they are false, not proving. So that's an incorrect statement. The difficulty belying his inability to do so comes from the fact that said statements were either so subjective they could not possibly be subject of truth or falsity, or were otherwise admitted to by appellant himself in deposition. That's not true. Subjective nature of Jamie Marquee's statements in the undated tweet and the February 7th tweet make it nearly impossible for appellant to put forth evidence disproving either, but the burden to do so nonetheless remains his. Appellant cites to no evidence establishing that he is not a bad person or that Marquee did not accurately express her fear, frustration, and anger, and thus has not met his burden, which he shouldn't, by the way. If he were to go and raise his own character as a good person, then evidence of him as a bad person would be admissible, whereas otherwise it's actually not admissible. Now, these are defamatory statements, so the statements themselves are in evidence, but if he raised his reputation as a defense, or if he raised his reputation to bolster his own case, they would then be able to attack that reputation, which they haven't been able to. So that would have been a bad choice all around. As to the February 8th tweet, appellant surprisingly claims to have specifically denied that he grabbed Marquee's hair, yanked her head back, and whispered something sexual in her ear. Let's take a look. Ms. Marquee certainly wouldn't be the first person whose hair you've pulled. No, we've established that. Speaking of taking this out of context, this is taken way out of context. This is not a sentence. If I remember correctly, he was actually talking and got cut off. So is it possible that Miss Marquee perceived pain when you pulled her hair in the lobby that day and that you were unaware of that? I had no indication when it happened there was anything offensive or painful about it. They take this out of context of the deposition as well, because he says, I didn't pull her hair. Appellant's own testimony establishes at a minimum, and so they'll have to counter this argument by actually showing the full context of this exchange, because it was not this simple. Even though they've conveniently edited it to look that simple. Notice there's no space between this Q&A, and there's no space between this Q&A, but there is space between this Q&A. That's because there's other stuff that happened between these statements. Appellant's own testimony establishes at a minimum that appellee Marquee's statement that he grabbed her hair and yanked it back is not false. That's not true. Though appellant asserts unnecessarily that he did not have sexual interest in appellee Marquee. No, let's get something very clear here. It is always necessary to assert that you don't have sexual interest in appellee Marquee, because that would be the most embarrassing thing on the planet. His testimony is contradictory and thus not clear and specific as to what he said into appellee Marquee's ear. Do you recall if you said anything into her ear? I don't recall that I said anything. If I did, it was literally something about, ooh, I love your hair, or love it, it's awesome. You know, it was that kind of thing. Would you agree with the statement that the way one person perceives a situation is not always going to be the same way everybody perceives the same situation? Of course. First of all, let's do a couple things. Vic should not have answered any of these questions. That's obvious. I hope everybody understands my criticism there. Vic should not have answered any of these questions. He should have said, none of that happened. None of it happened. Didn't happen. Didn't happen. But he didn't, because clients don't always do what you would want them to do. I mean, I assume, I don't know. It's not my client. So, but if it were me, I would say, no, you don't answer questions about this. Because did you do it? No. Then say no. That's it. That's all you have to do. But that being said, he should not have answered any questions about this. This is just a general question. Or wait, no, not this one. Where was it? This one. This is a general question, a general statement, and it doesn't say anything about the specific situation that they were in at all. So, but that's why you also shouldn't answer general questions. Appellant's testimony then is not that he didn't say anything to appellee Marquee while controlling her. It actually is, because he never ever admits to controlling her, and he took issue with that specifically. Only that he doesn't recall doing so. Yeah, again. He's taking these two things out of context. You recall if you said anything into her ear? I don't recall that I said anything. Not into her ear. I don't recall that I said anything. His testimony is not that he didn't say anything sexual to her either. He simply conveniently assumes that if he did say something, it must have been innocuous. Which is weird, because her statement conveniently assumes that if he said something, it must have been sexual. But if clear means unambiguous, sure, or free from doubt, and specific means explicit or relating to a particular named thing, appellant's alleged evidence is anything but clear and specific. Again, they're ignoring the parts of the transcript where he says that he didn't do this, or he takes issue with it, and then they're ignoring his express denials of it in his paperwork, in his own affidavit, stuff like that. As explained above, appellant misrepresents to the court appellee Marquee's statement regarding the fact that she had heard he engaged in similar actions towards other women. Appellant alleges that Marquee continued that he had done this exact thing to half a dozen other women that I personally know. Appellee Marquee only stated that she had heard that he had done so, not that he actually had. Appellant has not cited to any evidence in the record to establish that appellee Marquee did not hear such accounts, and therefore has not met his burden to prove falsity. So they'll have to, I mentioned this before, that hearing is a fact statement. They should shore this up. But by the way, just saying I heard doesn't make it not a statement of fact. And they can actually argue that she's still making a statement of fact and that every reader was to take it as a statement of fact. They can still argue that. And they can argue in the alternative that that the hearing of it is also contested because it never happened. So, saying I know it sounds weird, but just saying I heard or in my opinion doesn't make it not a statement of fact. There's actually case law supporting that specific premise, because otherwise everybody could just say, in my opinion, and then make a bunch of fact statements to ruin someone. They'll have to address it, especially now that it's been raised in the reply. And this is why they get a response. Not made with malice. Public figure must prove actual malice when suing for speech involving matters of public concern. Appellant was therefore required, especially with no error alleged as to the trial court's determination that he is in fact a public figure, to show that appellee's statements were made with knowledge or of reckless disregard for their alleged falsity. Actually, no, he does address this. I'm remembering in the appeal brief, they do address the public figure argument, stating that Chupp failed to dismiss the evidence that was provided to properly... They made a motion to strike the evidence that was provided to support the public figure argument as hearsay that violates the rules or is lacking foundation and all sorts of other things. Chupp chose not to do that. Chupp did not do that. So they raised in their petition that was improper, and that improperly included evidence led to the public figure determination, and that determination therefore shouldn't stand. So they did raise the public figure specifically as a point of error. But yeah. Okay. To show that appellee's statements were made with knowledge or of reckless disregard for their alleged falsity. In other words, appellant needed to show that appellee Marquee entertained serious doubts about the truth of her statements or had a high degree of awareness of the probable falsity. Instead, appellant cites to no evidence and has none regarding appellee Marquee's state of mind. Again, if you did it, if it happened to you, and you say that, or if you say something happened to you, but it didn't happen, then you know that was false, right? We understand that if my arm breaks and I say Q broke my arm with his arm and Q didn't break my arm with his arm, that's false. And I know that that's false because Q didn't do it. Like that, I know judges pretend to be stupid and the law requires them to do so, but we understand that, right? Okay. Appellant boldly claims in his brief that his contradictory vague denials are clear and specific evidence that Marquee's publication was false and that she knew her publication was false. Appellant testified otherwise. Do you have any evidence that you're aware of that Ms. Marquee did not actually believe these statements to be true at the time she wrote them? At the time she wrote them or at the time they happened? At the time she wrote them. I can't answer for her. I don't know what's in her mind. I can't say whether she believes it's true or whether she was just joining to pile on. I don't know. Because he can't know that. He can't know what's in her mind. This is a true statement. But again, that's why you don't answer these things. But that being said, this is, while he states it at deposition, he's asserting under oath in subsequent testimony and in all of his in his petitions and in motions that she stated that she did it falsely with malice, and that the malice is the knowledge of the falsity because they didn't happen. So it's weird that they're going. I mean, I know why he's trying to do this argument. He's trying to say it's not clear and specific, but he's raising fact questions, and fact questions that should be resolved in favor of the plaintiff. Appellant was required to show that Marchi acted with malice when publishing her statements, but did not do so. He has failed to cite to any statements that either accused him of a crime or of engaging in serious sexual misconduct beyond his generic reference to Vanderlinden versus Kahn. More importantly, the case law does not support appellant's vagueness. Citing Masson versus New Yorker magazine, publishing a statement with ill will, spite, hatred, or wanton desire to injure is insufficient to establish actual malice. Hart Hanks, difference of opinions about the truth of a statement is insufficient to establish actual malice. And Forbes Inc. versus Granada Biosciences, poor word choice and use of imprecise language is insufficient to establish actual malice. The only statement in the record that actually contains a statement of fact about appellant is one in which appellee Marchi outcries with the truth about what appellant did to her, something he has said is not true, a statement that is conspicuously missing from appellant's filings in the trial court. Equally conspicuous is that appellant admitted to the truth of appellee Marchi's statement in his deposition, which is why appellant is unable to summon clear and specific evidence. He references, I want to be clear on this. The statement itself, like the full statement, is not included in the pleadings, but references to the statements and a summary of the statement is included in the pleadings. And then that clear and specific part of the evidence comes up because that statement is otherwise in the record in several places. No one's denying that Marchi made the statement that they're referencing in the pleading. Sam's trying to dance around this issue here, but that statement is actually in the filings in the trial court and in the filings in the appellate court. They'll want to clarify that and point out all the places that that statement appears in the record, and they'll want to point out where it appears in their initial pleadings as well, because it's there. It's in all three, if I remember right. Reference by reference. Say, on February 8th, Jamie Marquee made this tweet, so-and-so. Equally, and I think it's actually included in the second amended petition in its entirety in the supplements. Equally conspicuous is that appellant admitted to the truth of Marchi's statement in his deposition. Notice he's repeated this a lot because he wants that to stick, even though it's not actually true. And they'll have to shore up that argument as well by pulling from the deposition where he says, I take issue with the term pulling. He should just go ahead. They should just cite that over and over and over, which is why appellant is unable to summon clear and specific evidence, among other things, that appellee Marchi acted with malice. Perhaps most importantly, though, is that Marchi's own statement before involvement of counsel, at which she wrote wholly on her own, clarifies that her intent was to protect herself and the public at large and for no other reason. That doesn't really do it. That doesn't make something you say non-defamatory, so that's weird. No evidence of damages. Finally, appellant's claim that any damages were caused by appellee Marchi is respectfully ludicrous. In addition to his failure to provide any evidence of malice based on his, appellant has also failed to set up a cognizable claim for defamation per se. Appellant's burden in both circumstances is to prove general damage for his libel per quad claim. Wait, what? Oh, since it's not per se, it's per quad. That's what they're saying. Appellant confirmed that appellee Marchi's name was never mentioned by Funimation when it was conducting the investigation, which led to termination of his contract. Appellant also testified in his deposition that Marchi's statements could not have impacted termination of his contracts with conventions before the statements were published. Appellant has not specifically cited any conventions canceled after the date of appellee Marchi's statements. As of his deposition, appellant was even on track for his typical annual number of convention appearances, having already appeared in 9 at that time and professing attendance at 20 to 30 in any given year. Rather than provide clear and specific evidence of damages, appellant's evidence only establishes the absence thereof. That's not true. Plus, if their per se argument succeeds, then damages are presumed in general. But loss, you don't just have to have financial loss that is out there. You can, loss of reputation is shockingly part of damages. Appellant's lack of explanation or citation on his alleged damages arguably amount to waiver of this part of claims altogether. Okay. Issue number 2. Trial court's dismissal of appellant's claims for TI with existing contracts against Marchi is not reversible error. This is going to be... What? I don't know what that is. Oh, okay. This is going to be a strong section of their case. And here's why. Because the entire theory, as best I can figure, on the TI with existing contracts and the TI with prospective business relations against Marchi hinge heavily on the civil conspiracy claim, which was not eloquently argued at the TCPA hearing. Partly because of how Chup conducted it, but he didn't want to hear how all of this fit together. What he wanted to do is go one issue at a time, and he started with Marchi. Good for her. That's just how it goes sometimes. And maybe they should have shored up that argument better, or tried to assert it more in court. Who knows? Easy to sideline quarterback that hearing, but being there, it's hard to say that they would be able to get any sort of argument out of that trial court, out at that trial court. Chup was not hearing deviations from his plan. Defamatory per se means that it's defamatory as a matter of law. Per quad, I don't know the exact translation of the Latin, but basically it's defamatory as an operation of all of the factors involved, right? Per se means it's defamatory on its face. As a matter of law, this is defamatory. If I say that you raped someone, it's per se defamatory. Per quad means all of the factors add up to defamation. So hopefully that helps. Appellant sorely failed to meet his burden to proffer clear and specific evidence that he had a valid contract. Marchi willfully and intentionally interfered with the contract. Marchi's interference proximately caused appellant's alleged injury, and appellant incurred actual damage or loss. Just as in the trial court below, Marchi struggles to respond to appellant's allegations because they can scarcely be said to exist in the first place. Marchi cannot help but point out that the court has not a single page of the record cited to by appellant specifically references Marchi. Because appellant's pleadings and citations to the record offered no guidance, Marchi will respond to the generalities alleged in the appellant's brief. And again, I think it's mainly because they're alleging conspiracy against Marchi that they're going with the underlying torts supporting the conspiracy. But this has always been a weak claim against Marchi. Appellant alleges that Marchi knew appellant attended such conventions. Appellee Marchi attended some with him. Appellant doesn't attempt to identify the element for which this fact, assuming its veracity, sets up a prima facie case, probably because it doesn't. Appellant vaguely argues that several conventions canceled his appearances in breach of his contracts with them because of appellee's defaming statements. However, appellant's arguments are not supported by the record in this case. The only evidence cited to by appellant are his withdrawn affidavit, again, his untimely filed sham affidavit. It wasn't an affidavit, it was an unsworn declaration. And what makes it a sham? That's interesting. See, using this inflammatory language in the appeals court, I don't think gets you very far. Because now they can specifically say that his unsworn declaration was not a sham at all. It's signed by him, a party, and it was to replace a defectively notarized affidavit. And a portion of his testimony questioning whether he had taken any medications on the day of his deposition. Appellant did admit under oath, though, that he knew of no conventions that appellee Marchi even contacted. Finally, continuing the static on the screen in lieu of a clear picture. Oh, that's a cute idiom. Appellant broadly states that he suffered actual damages due to these cancellations, again citing only to his withdrawn/tardy sham affidavit. Again, this is not the best look. This is not winning the points. I mean, it's winning the points for law Twitter or whatever, but this language in the appeals brief isn't helpful. And again, because they can say there's nothing, the only sham about the affidavit is that they know that it's devastating to them. Neither of which can be properly considered. again, you're arguing. This is interesting because they're proffering the argument that they would have things to say if they included the affidavit that Judge Chupp threw out, or the unsworn declaration that Judge Chupp failed to acknowledge. That's a weird tactic to take, because the court might just say, well, we want to see what's in there, and we want to see if that should matter. And if it does matter, they might remand it. Knowing that appellant's burden was to put forth clear and specific evidence establishing a prima facie case for each element of this claim, one must seriously wonder why this is asserted as a point of error at all. Despite bringing this claim in the first place, having ample opportunity to brief it with supporting evidence, if any exists, in the trial court, and then taking one final bite at the apple before this court, appellant offers nothing in the record paired with only vague and general argument, a far cry from clear and specific evidence. Now, again, this is going to be a strong section, as I said, and should be. Sam should be dunking on this section. Absolutely. It was a weak case against Marchi for the TI with contracts and TI with business relations, unless you've got her on the conspiracy. If you've got her on the conspiracy aspect of it, then you can rope her into those other things. But without that, you don't have it. You don't have it. And so they're going to act like they don't have it for sure. And they may not be able to get Marchi on the conspiracy stuff as well. You know, we'll see. Issue number 3, trial court's dismissal of appellant's claims for TI with prospective business relations against Marchi is not reversible error. Appellant also fails to show this court where the record contains clear and specific evidence that there was a reasonable probability that would have entered into a business relationship with a third person. Marchi intentionally interfered with the relationship. Marchi's conduct was independently tortious or unlawful. Marchi's interference proximately caused appellant's alleged injury, and appellant suffered actual damage or loss in order to sustain his claim against appellee Marchi for tortious interference with prospective relations. What the underlying tort is the defamatory tweet, I'm guessing, other than the civil conspiracy, but the defamatory tweet would go to this. If conventions canceled him due to the defamatory tweet, or more importantly, if conventions would have refused to hire him due to the defamatory tweet, which we can definitely argue is true. Like, they may be able to argue better at the trial court level that it's false, but at this point, you could plausibly state that the nature of her statement, and this is what their argument is in a nutshell, the nature of her defamatory statement is so damaging to Vic that it would prevent future contractors whom she's aware of those future contractors because she's in the industry and she knows how the convention subcontracting or the convention contracts work, as well as contracts with any employers or prospective employers would work. But she's aware of those, and she would know that this statement would cause those things to not happen, which would cause damage to him. That's the theory. Again, with Marchi specifically, it's a weak theory outside of the civil conspiracy because otherwise you have the defamation claim, which is stronger by itself. And using the defamation to support the TI with prospective business relations, the defamation is going to be the better claim anyway at the end of the day. But that being said, we have what we have. We have what we have. Appellee Marchi does not dispute that appellant previously and regularly appeared at several fan conventions each year. What appellant doesn't want to own up to, however, is that he was rarely invited to the same convention consecutively, and that his attendance at conventions fluctuated from year to year. Oh, he doesn't want to own up to that. That's actually, he addressed that specifically in his deposition and said it's rare to go to the same convention twice, 2 years in a row. And he did actually attend several conventions regularly being every other year to every third year. So this is a weird approach because, again, like, you have this argument already, but this need to dunk on Vic here opens them up for a response that says, no, he actually addressed this. And in the industry, you often would go to a different convention each year, and that he was not specifically disinvited from any convention that he's ever been aware of. and that every convention that's ever said that, or that anyone has said that he has been blacklisted from, he's actually gone back to. That's the whole, Jaw Marshmallow or whatever. That's her entire problem with, what was it? Was it Sakura-con? Azumi-con? I don't remember which one. Was that she would say he was banned, and then the next year he would go. Like, well, wait, he was banned. It's like, he wasn't banned, you idiot. He just didn't go the previous year. Appellant does fail to establish by... But again, since they've brought this in now, they've just set up a place where they can argue against their own words. Where Vic's team can say, whoa, 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 this is actually a misrepresentation. And she knows it. Appellant does fail to establish by any evidence that Marchi ever interacted with any interfered with any business relationship appellant may have had with a third party, that she did so tortiously or unlawfully, that she did proximately cause any alleged damages, or that he was in fact damaged. Indeed, appellant testified that he didn't know of a single convention appellee Marchi had reached out to. But the underlying tort, see, this is the trick. The underlying tort of defamation doesn't necessarily require you to reach out specifically to a convention. That would be tortious interference with existing contracts. If she knew he had an agreement with a convention and then reached out to them to interfere. The tortious interference with prospective business relations is her defamatory statements by themselves are so egregious that they would suffer. Now, I don't know if that's a winning argument, but that seems to be the argument. And that's why it requires an underlying tort. What did you do that makes this interference with prospective business relations? By lumping in all appellees together, appellant has necessarily defeated any argument that they are each the cause of any alleged damages. That's not how that works, actually. Appellant relies heavily on limited Texas jurisprudence that in a TCPA review, the court may draw reasonable inferences from circumstantial evidence, citing to Beving versus Beatles, for the supposition that because appellant thinks he cobbled together documents that he interprets a certain way, the trial court should have done the same, and this court should also. This is actually, again, this is a bad argument. This is not the... Sam is taking really weird approaches here because he's already got this. He's already got the victory. So admitting that the appellant got documents together and interprets them in a way in which you could draw a reasonable inference. Look at this. However, just because a court could draw reasonable inferences does not require that it should. But prima facie evidence is the minimum quantum of evidence to support any rational inference. Any. So he's saying that just because a court could draw reasonable inferences does not require that it should. He's tacitly admitting that there could be reasonable inferences in what Vic has done here. This is a bad approach to the appeal. And again, I don't know what they're going to do. I don't know what they're going to do on the response brief. Let me be very clear on that. But if I were on the response brief, pounce on this. Appellee's counsel flat out admits that a court could draw reasonable inferences, just that it shouldn't. Well, why shouldn't it? Because obviously it would be devastating if they did. They admit right here that the appellant believes he cobbled together documents and interprets them in a way that is, by function of these two sentences, reasonable. That's a bad pair of statements to put together. I wouldn't do that if I were writing the document. I don't think Sam should have. Because remember, Sam has already won this argument. And he won it again here. He doesn't need to do this here. Inferences drawn from circumstances must indeed actually be reasonable ones. You just said reasonable inferences. Where inferences from circumstantial evidence are speculative and conclusory, just as are the inferences appellant relies on in the hope of having a claim, there's simply too great an analytical gap for this court to traverse. That's up to the individual courts, and that didn't actually happen at the trial court level. And that's going to be the basis for their argument. So he argues up here that he believes he's compiled together reasonable inferences, and the trial court should defer to the plaintiff on those beliefs. That's what I would argue. And again, like, you're charging uphill if you're Vic on this claim, but Sam just he opened a door. I'd spend some time on it. As previously stated, knowing the appellant's burden was to put forth clear and specific evidence establishing a prima facie case for each element of this claim, one must also seriously wonder why this is asserted as a point of error at all. Appellant again offers nothing in the record paired with only vague and general arguments, a far cry from clear and specific evidence. Issue number 4, not applicable to appellee Marchi. Appellant's fourth point of error neither implicates nor references Marchi. Trial court's dismissal of appellant's claim for civil conspiracy against Marchi is not reversible error. Appellant misinterprets this court's prior opinions to allege that a civil conspiracy claim cannot be dismissed by virtue of the TCPA. Appellant alleges that his conspiracy claim is not subject to the TCPA because appellee's actions were not in furtherance of a protected common interest. Boiled down, appellant's claim seems to be that because he believes appellees didn't establish that their conduct was promoting, pursuing, or defending the larger common interest, dismissal under the TCPA was inappropriate. Appellant is wrong. Well, maybe. If the legislature had intended to limit the TCPA's applicability to civil conspiracy claims, it would have done so when it enacted the TCPA. Marchi set forth in her TCPA motion numerous bases for applicability of the TCPA to appellant's claims, including her constitutional right of association, but also that her statements involved a matter of public concern, namely because appellant is a public figure and because her statements relate to the health, safety, and community well-being. This is actually, they should have, in my opinion, spent more time going after this argument because this is bullshit, right? This is absolute nonsense. This is a bad, stupid argument that they should have attacked heavier in their responses. But at the end of the day, what do you got? Appellant did not appeal the trial court's order as to applicability of the TCPA to his claims, e.g. that, among other things, Marchi's statements invoked a right of association, only the dismissal of same. As such, appellant is limited in his argument to alleging that he put forth clear and specific evidence of a prima facie case of each element of his civil conspiracy claim, which he did not do. Wait a minute. What? He's splitting hairs here because he's basically saying, okay, we're responding to the fact that that they're saying the application of the TCPA is improper, but he didn't say that the application of the TCPA was improper, only that the dismissal under the TCPA was improper. That's a weird thing. Appellant ignores both in the trial court and in his brief to this court, it was his burden to bring forth evidence that Marchi was a member of a combination of two or more persons. The object of the combination was to accomplish either an unlawful purpose or lawful purpose by unlawful means. The members had a meeting of the minds on the object of course of action. One of the members committed an unlawful, overt act to further the object of the course of action, and appellant suffered injury as a proximate result of the wrongful act. Nothing in the record even hints at a single of those elements, and appellant has made no effort to enumerate for this court clear and specific evidence as to each element. That's because they're arguing that the application of the TCPA to the civil conspiracy claim in general was not allowed. I mean, that's the argument that they chose. So they didn't go through the elements of civil conspiracy because they just argued flat out that the civil conspiracy shouldn't have been dismissed under the TCPA at all because TCPA doesn't apply to it. Finally, a claim for civil conspiracy in Texas relies on the commission of another civil wrong. Proof of conspiracy by itself does not create liability. With appellant's substantive claims against Marchi dismissed, appellant's civil conspiracy claim cannot stand and was also necessarily dismissed by the trial court. Yeah, and again, they're arguing with the assumption that the defamation claim at least will go back. That's clearly the tactic that they're taking here. The trial court properly refused to consider appellant's untimely second amended petition. This is going to be the interesting argument, and this is a place where I think Vic's team has some position to really push on this, and they need to shore this up because that second amended petition matters, and you can tell it matters because they really, really don't want it in there. If the second amended petition and the unsworn affidavits get in, or the unsworn declarations get in, then there are problems, serious problems that the trial court overlooked, and the appellate court might just go ahead and send it all back, either remanding it for another TCPA or just letting it pass TCPA and go to trial. That's the big problem that they've got, this issue right here. And this is probably where Vic's response will spend most of its time. And this is where we're going to see some pretty serious arguments from each side. All right. Appellant argues that the trial court had no discretion to disregard appellant's untimely second amended petition, particularly the hundreds of pages of new, additional alleged evidence attached to them. They should immediately attack this. The evidence wasn't new. It was merely condensed. They should immediately attack this, and Sam shouldn't have brought it up at all. Because basically, everything outside of the unsworn declarations, if I remember correctly, appears otherwise in the record. So everything outside of those declarations appears otherwise in the record. And so suggesting that there's hundreds of pages of new alleged evidence is factually untrue, and it's misrepresenting the nature of those documents to the court. And now they will be able to bring those up to the appeals court in their response and say, actually, nothing in there was new. It's included here, 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 and cite to the record everywhere else. And cite to the fact that they had actually responded to the faulty affidavits. In their responses, they had actually dealt with the faulty affidavits, even though they were withdrawn, and cite to the fact that the unsworn declarations did not provide any element of surprise because it's the same information. Literally, it's just an unsworn declaration versus an affidavit. And with those unsworn declarations, they have actually not introduced anything new. They hammer on that. And now the appeals court has something to look at. And partly because Sam here has just said that it's hundreds of pages of new additional alleged evidence. But if it's not new, and they can show that it's not new, now the appeals court has to go, wait a minute, this wasn't new. It's not new at all. This should be in there. It's right there. I wouldn't have done this. Again, his need to be snarky and dunk might be an opening. Now, the other team has to take advantage of the opening for it to be effective. And then the appeals court has to also get interested in it, right? Like those things have to occur. I'm just saying, if I were on Vic's team writing this appeal, my response would hammer on this weird false claim of Sam's. Neither the record in this case nor the Texas Rules of Civil Procedure support appellate's conclusion. Why not? Because the best place to start is off in the beginning. Rule 1 offers guidance. The proper objective of the Rules of Civil Procedure is to obtain a just, fair, equitable, and impartial adjudication of the rights of litigants under established principles of substantive law. That's interesting, because you're saying you should exclude good evidence, which would be unjust and unfair and not equitable. Appellant's burden in this point of error then is to show why the trial court's refusal to consider his tardy second amended petition, except they're alleging it wasn't tardy at all because there isn't actually a timeline, prevented a just, fair, equitable, and impartial adjudication of the rights of the parties. He cannot do so. Appellant filed his original petition on April 18th, 2019, and the record is clear that he had been investigating his baseless claims well beforehand. After Marchi filed her TCPA motion on July 19th, appellant had a month and a half before his response was due. Indeed, the parties set forth an agreed schedule clarifying the deadlines and confirming agreements. August 30th, appellant's responses and objections. September 3rd, appellee's replies and objections. September 6th, hearing on TCPA motion. Now, importantly, notice what's not in here, and they will point this out if my fortune telling is correct. What's not in here is amended petitions. Amended pleadings are not included in this Rule 11 agreement that they're referring to. This schedule was agreed to the parties in a signed Rule 11 agreement and filed with the court. Appellant's responses to the TCPA motions, which the appellant is not required to respond to. By the way, they're not required to respond to it. They can do the entire response at the hearing. In fact, the real prophet of everything, T. Greg Doucette, specifically criticized Ty and his team for responding at all, saying that he could have just responded at the hearing. T. Greg brought that up. So here's the thing that's very, very interesting about this is there is nothing mentioned the amending of pleadings in the Rule 11 agreement. And again, this is a track which will open up the appeals court to say, for Vic's team to say, we never agreed to not amend our pleadings. And in fact, we can show here, here, and here where the recommended course of action is amended pleadings. Ty mentioned at the TCPA hearing that the recommended course of action in continuing legal education is to amend the pleadings. That's a known tactic for TCPA. Amend the pleadings if there are alleged deficiencies in what's going on. And the trial court's authority to adopt the amended pleadings is broad. They should allow it to happen so long as there is no surprise. So we've got issues here. And now again, Sam has in his own argument, he's opened the door. Hopefully they take advantage. This schedule was agreed. Yeah. The schedule was thereafter binding on the parties without recourse. And again, when the judge asked at the hearing, are you trying to get around the Rule 11 agreement? He says no. Because he wasn't. After appellant failed to timely file his response due to alleged technical difficulties, trial court deemed it timely filed. So again, this doesn't matter. 3 days later, though, on the same day, appellee's replies to appellant's response were due. Appellant, without warning or explanation, filed a second amended petition containing hundreds, which is Monday. And actually, I don't know if they filed it on Monday. I can't remember the exact timeline of the filing. Filed a second amended petition containing hundreds of pages of documents that were not attached to his initial response and reattaching the remainder of the alleged evidence that was attached to his response. Hardly an action that could be deemed just or equitable, unless all of that information wasn't new. That's the problem, right? Was it new or was it just condensed? Citing a learned treatise on the subject, the trial court ruled that amendment after a TCPA motion is filed would be contrary to the purpose of the statute and possibly a violation of the Texas Rules of Civil Procedure. And again, this is a bad premise, bad choice. That learned treatise is a law review article about the new TCPA that they were not under and does not actually show why it would be a violation of the rules of civil procedure and has nothing to do with actually being, they don't actually have any case law to cite that it's contrary to the purpose of the statute. That learned treatise had a bad statement here that Judge Chuck pulled out of his ass to justify his decision. This was actually a bad citation, and if you brought it into Chupp's court, he would have been pissed. So again, I don't... Said treatise references a case out of the Dallas Court of Appeals that holding that a motion to dismiss under the Texas Medical Liability Act could not be subverted by filing an amended petition, and a California case that finding that the trial court there properly denied a request to file a proposed amended complaint while an anti-SLAPP motion was pending. Okay, so you've got a California case and then a Texas case under a completely different statute. That functions differently than the TCPA, might I add. They are different in function as they go. some law review articles, guys, actually many law review articles are actually propositional in how the courts or the legislature should deal with things going forward. They don't actually comment on how things are. This is, again, an argument that is not well founded, and it references the new TCPA. It's not referencing the TCPA under which they are already arguing, because if you remember, after they filed their initial complaint, the TCPA received an amendment to it, and it changed the function of the TCPA in several different ways. And they will argue that they are under the old TCPA, and the article in question specifically references the updated TCPA law. So they have several avenues of attacking this argument already. This court has also ruled that an amended petition filed after defendant's filing of a motion to dismiss under the Texas Medical Liability Act, again, was wrongly considered by the trial court and remanded for an entry of an order dismissing the plaintiff's claims. Again, we're not under the Texas Medical Liability Act. Support for the trial court's determination also exists in other rules of procedure and cases interpreting them. Texas Supreme Court expressly requires the trial court to rule on a 91A motion to dismiss without regard to a late filed amended petition. In the summary judgment context, a summary judgment proceeding is a trial within the meaning of Rule 63. But this isn't a summary judgment proceeding, and that's interesting here. Rule 63, of course, dictates that a filing within 7 days of a trial may only be filed after obtaining leave of the court, which appellant did not do. Appellee Marchi, together with other appellees, objected to appellant's second amended petition, showing that based on this case history, parties' Rule 11 agreement, proximity to the hearing, and being filed on the same day as appellee's responses were due, appellant's second amended petition functioned as a surprise. Trial court had discretion to agree with appellees and disregard the second amended petition, which it did. The trial court properly disregarded the new alleged declarations appellant untimely filed. Even if it had considered such evidence, though, the evidence offered was neither based on personal knowledge, factual assertion, nor anything other than hearsay and speculation. This is absolutely untrue. These are absolutely untrue. And they didn't object to those in their filings on the affidavits. This is flat out lies. Like, this is... Whew. Appellee Marquee satisfied her evidentiary burden, and appellant did not preserve any alleged objection to such evidence. I expected a better section from Sam on this, because this is, in my opinion, this is one of the most, if not the most important sections. He spends a lot of time, not really a lot, but he doesn't say very much. I would have focused, I don't know what other arguments he could make, but the way he made these arguments, like I said, it leaves some doors open to attack. Oh, here we go. Disregarded the new alleged declarations without intending to cast aspersions on the alleged witness or appellant. Appellee Marquee notes a considerable difference in the alleged signature of one of the declarations tardily filed by appellant. Wait. What? Without intending to cast aspersions, they're casting aspersions. A considerable difference in the alleged signature of one of the declarations tardily filed by appellant. So they're saying that the signatures, are they claiming the signatures are forged? Is that the argument? Because this footnote is fucking improper if you're not actually going to claim that the signature was forged. That's pretty ballsy. Marquee satisfied her evidentiary burden, and appellant did not preserve any alleged objection to such evidence. Appellant conflates all appellees in point of error 7 of his briefing regarding satisfaction of appellee's evidentiary burdens, but does not make any reference to appellee Marquee nor citation to any of her evidence or any objections to the same. Appellant has therefore waived this complaint to the court with regard to appellee Marquee. Moreover, though he did object to appellee's Funimation Real and Toy's evidence in the trial court, appellant did not object to any of appellee Marquee's evidence, and the record contains no such objections. As a result, any objection appellant may allege as to Marquee's evidence is waived. I'm not sure what this is on. Trial court's award of attorney's fees to Marquee and sanctions against appellant is not reversible error. Appellant admits by implication that if the court affirms the trial court's dismissal of his claim, admits by implication. dismissal of his claims against Marchi, then the trial court's award of attorney's fees and sanctions as mandated by Texas Civil Practice and Remedies Code 27.009 was not improper because appellant did not raise any complaint as to the trial court's determination of reasonable and necessary attorney's fees awarded to Marchi or the sanctions assessed against appellant. He has waived any alleged error on those issues. Rather than belabor the point, Marchi simply states that when this court affirms dismissal of appellant's claims against her, it must also affirm the award of attorney's fees and sanctions. Missed opportunity! Sam, no! Sam should have, in my opinion, said it must further affirm the contingent fees awarded in the attorney's fees and sanctions award, because he says here just the attorney's fees and sanctions. He should go with the contingent fees as well. That's a missed opportunity. It would have taken an additional sentence. That's it. Just an additional sentence or so. I still contend that those fees, the contingent fees, are a problem. They are unjust because the notice of appeal had already been filed, and that should be argued. Though they have not argued it yet. I don't know if they will in their response brief, but that those contingent fees shouldn't exist, in my opinion. But I'm just a humble man. Conclusion. Considering appellant's lack of substantive briefing and the vacuous record before this court, trial court reached the correct outcome, dismissal of appellant's claims against appellee Marchi. Only by offering clear and specific evidence of each element of each of his claims could appellant have avoided this outcome. He was unable to do so in the trial court and remains unable to do so here. Not only does the record establish that Marchi neither made actionable statements under Texas law, nor engaged in any action that interfered with appellant's business dealings, it shows that appellant merely seeks to place blame on others for his own self-imposed misfortune, an outcome not permitted by Texas law. Taking these truths together with the protections afforded by the TCPA, the trial court properly dismissed appellant's claims. Regarding appellant's consistent misdirection and disregard for the Texas Rules of Civil Procedure and the parties' Rule 11 agreement, appellant's late filings and tardy submission of alleged evidence was improper, cannot be allowed to set a precedent for future litigants. On the contrary, the rules require order, justness, fairness, and equity, lest litigants and aggressors be given too much freedom to abuse Texas' legal system after they abuse those in their lives. This court should and must affirm. Appellee Jamie Marquee respectfully praised the Court of Appeals, affirm the orders dismissing appellant's claims and awarding Marquee attorney's fees and sanctions, grant appellee your costs of court of this appeal and $37,500 in conditional appellate fees for briefing to this court on appeal, and grant to appellee such other and further relief, both at law and equity, to which appellee may be justly entitled. There you go. Sam Johnson. Without casting aspersions, this signature looks different than another one I saw. So there you go, guys. That is the document. That is the document that we have. Shockingly, no mention of the GoFundMe. I do think Sam rather competently wrote the document. Make no mistake, I have some criticisms there, but it's a good argument. It's well drafted for the most part. I think he's made some errors that can be pounced on by the opponents, by Vic, and hopefully they will do something akin to that in there. I mean, he acknowledges one thing that we've known for a while in looking at these documents. The case against Marchi, especially in regards to the tortious interference claims, is weak. It always was weak. I was always waiting to see if there would be more evidence included involving her participation in the tortious interference. But the main thing we had for evidence against her was the defamatory nature of her statements, and then her potential involvement in a civil conspiracy. As for the TI, that really just flows from the civil conspiracy claims, as far as I can tell. I haven't seen anything to change my mind on that, and Sam properly attacked that in this document, and I think that's his main job. Now, he did his best on the tweet, although I think Vic's team's main goal here should be to point out that not only, that tweet is in there and contains statements of facts, and while they have determined that here's the setup, while they have determined that there are different ways to interpret those statements of fact, and that there's some vagueness or there's some discrepancy there, that the trial court is obligated in a prima facie finding to determine or to resolve all factual differences in favor of the plaintiff and to assume any uncontroverted evidence as true. Okay, so if it's uncontroverted at all, it's true. If there are differences of opinion on how that evidence is to be interpreted, those weigh in favor of the plaintiff. And therefore, they've acknowledged that the statement is in there. They've acknowledged that he says it's false or that he takes issues with the truthfulness of it. It happened to Jamie Marquee allegedly, so she would know that those statements were false because she was the actual participant, and that they caused damage. All of the elements are there, and they're there in the appellant brief, and they should hit on that extremely hard with regards to Marchi and point out that all this was there, and they should maybe even cite to the transcript of the hearing in which Judge Shupp specifically asked Sam Johnson if there were statements of fact in that tweet about pulling hair and other things, and Sam said yes. Sam said, yes, Your Honor, those would be statements of fact. They should go ahead and put all that in there because it's in the record. It's in the record. And they should hammer on that and point out that, it's right there. They've admitted that all of this took place. Now a jury gets to decide how much damage was caused by this statement. And that's up to a jury. That's the fact finder's job. That's not the TCPA's job. They have properly alleged all of that stuff. And by the fact that she said something sexual, that implies sexual misconduct. Actually, no, it doesn't even imply sexual misconduct. That is an explicit statement of sexual misconduct. And the conduct described would be sexual harassment and would be, quote unquote, that of a sexual predator, which she was clearly referencing in her other tweet. And that rises to the level of defamation per se. But even in the alternative, that he was clearly damaged in his reputation, in his businesses by these claims. So. That's what they need to focus on. They really, for Marchi's claims, based on what's in the appellate brief, they don't need the second amended petition for her claim. They don't. For the defamation, they don't need it at all. It's all right there. It's in the appellee's brief. They've included all of the information for the defamation claim. TI with contract and TI with prospective business relations, I think likely those stay dismissed on Marchi. Civil conspiracy, if they can stick the defamation claim, there's a minor chance they get the civil conspiracy claim. I think the defamation claim was always the strongest one they had against Marchi. And I think they can still get it. I mean, they can point out, as appellees point out, this statement is in the record. As appellees point out, here's all of the elements of defamation right here. What appellees misrepresent is this, saying it wasn't in the initial pleadings when it was. It was referenced specifically with specific statements about pulling the hair and splitting the fingers and all of that crap. Those are the defamatory statements made. Here we go. The trial court has everything they need to make a rational inference that this was a defamatory statement that was made about the plaintiff, made by the defendant, that it was false, that it caused damage, and that it was made with malice. Because she would know that it didn't happen. Because it didn't happen. So there you go. That's what they really need to do. They really need to dump in on. If I were writing the appeal, that's what I would do. Obviously, I'm not the attorney. All right, guys, I think we're good for tonight. I mean, I'm going to go through the chats that have come in, of course. We're going to go through those. But other than that, we are going to, what am I going to say? What was I going to say? Yeah, we'll see what happens tomorrow. Tomorrow will likely be the Funimation appellant brief. I'll see if I can pre-screen it because it's 70 pages. This was 45. It's 70 pages, which seems like maybe they went over their word count. I don't know. I'd have to check if they went over their word count. Maybe they asked for an extension of the word count in the document. I haven't read it yet. I'll see if I can weed out similar stuff. But they have 70 pages. I'm not sure what else they've included in it, but that's what they've got. So, and then we'll see. But if Ethan wants to come on tomorrow, I would have Ethan on tomorrow first. Otherwise, if Ethan wants to come on Thursday or Friday, of course, I'd love to have him on then as well. Cyberfrog Wrecked Planet is absolutely dominating Indiegogo right now, doing extremely well. I couldn't be happier for him. Like I said, guys, I want all independent creators to have success, and so I would love to have him come on and talk about it. Tell you guys what he's working on and what he's doing, and then also to talk about where the comics industry is going, because if you've been following it all, Diamond Distribution has shut down the distribution of mainstream comics completely because they loved that monopoly so much and fed it for so long that when the time came that it mattered, they just shut them down straight out. And it's great. So I will be on Twitch tonight as well. So if you want to come over to Twitch, watch me play, I guess, Doom 2016 some more, or not 2016, Doom Eternal some more, come do that. But other than that, let's hit these chats and let's wrap up for the night. All right, Mercenary, no wait. Is this our first one? Gamer Hands Jr. says, I've been waiting a whole year for this. Oh, hey. Also, Nick, I had a blast meeting you at Kitchener Comic Con. Video will be uploaded tomorrow. Into the chat, press 1. Whoa. Press 1 if you think Marquee's let herself go, or 2 if she's worth the ring to put on it. Anyway, thank you, Rackets. So there you go, guys. You can Gamer Hands Jr. Inc. 1 if Marquee's let herself go, 2 if it's worth the ring. Mercenary X says, Nick, I need all the praying I can get right now. I'm worried about my dad considering how stubborn he is being German, and how he goes everywhere. I need any and all praying to make sure he doesn't have beer bug. I'm worried Mom is taking him to the doctor tomorrow. Hey man, I will specifically pray for him between shows. Also, please pray for a man, I think it was Virginia, who basically shot at 3 masked armed assailants and is now facing 25 to life. Tucker Carlson just covered it tonight. Please cover the case of this man because he needs justice as bad as Vic, really bad. Hey, if you could do me a favor and just email me some name or something or an article I can look at so I can check it out. Gamer Hands Jr. Inc. says, yo, the chat, press 1 if you think Marquee's lying about the bullshit that we see right now. Also, Mr. Raggets, can you say, if you smell what the spirit is cooking? P.S. Also, I'm the guy that faced Marquee and called her out. Oh, so that's Spirit Jr. So there you go, guys. Jay says, did Sam drink the Lemoyne mosquito juice? Some of that is painful to read. It's nice of Sam to assert himself as a handwriting expert. I mean, what else is there, right? That's that footnote is absolutely improper. Especially because I believe they're talking about Vic's signature. So they're saying that Vic lied about signing his own document. Weird. Ryan Gordon says, I've had a hard time convincing my wife that police are not our authority. The law is. We're supposed to be police authority. Been talking with her about all that with this COVID nonsense. One thing I'll tell you is you comply with the police in the streets. Don't comply with them in the sheets. Ryan Gordon says, I can see the gel flakes in your hair. Looking like something about Mary. Oh, no. Listen, we're not going to talk about it. Viden the Cold One says, joke's on you, I wear a ponytail. Timothy Reaper says, did you hear about the Trump / My Pillow Guy team up? I saw something briefly. I didn't watch it. I just saw a clip on Twitter. Cato Sierra says, update, it's been 14 days, so if I get the hashtag CCP virus, it almost definitely wasn't because I went to drink Guinness all night. Either way, it's she's fault. Xi Jinping. Count Camp says, shut up and take my money. Lol, hope you're doing well. I am, buddy. Hope you're doing well as well. Gawker's Death Rattle says, last super chat, I was waiting on a COVID test, which came back negative. I'm going to live to be grifted another day. Hey, great. I'm glad. Live, my friend. 2012 Jameson says, did you see 4-lawyer TCPA case? It's funny, Fort Worth. Some people sent it to me. I haven't read through it yet. Stephen Welsh says, quick baby update. Baby and mom are doing great. Oh, that's awesome. Congratulations to all of you. And I'm so glad that everybody's doing well. Lagging says, sorry, couldn't catch the show live earlier. The YouTuber Frederick Knudsen has a Down the Rabbit Hole episode on Darkside Phil. It's a good primer. Thanks a bunch. Justin Blood says, I have a good reading recommendation for you. The Red Rising series by Pierce Brown. Great sci-fi story. Violent and action-packed. Ooh, right up my alley. Chengiz Khan says, so Peacock got his channel up before Drex. Nick, tell Drex to stop diddling MILFs and get that channel up and running. Listen, I'm never going to tell a man to stop diddling MILFs. Dave94 says, thanks, Nick, for reading my ad/super chat yesterday. If you don't mind, I can keep super chatting you. Listen, I'm not going to complain. Also, the intro of this video was hilarious. Hey, thank you. Big Red Bear says, I think everything you're saying can be encompassed in Cicero's words cui bono. Sky Hime says, Ty should parade 100 real victims to shame this farce of an allegation. I'm sure real victims forget very little of their assaults, especially the things said. Yeah, unfortunately, I think the things that are said to them probably haunt them the most. Steve Oman 16 says, DSP is the cure against Corona and will have all his debts absolved. Hashtag gout cures all. Lagging says, I figured it out. He's just practicing all the arguments he's going to use in court when they lose the appeals. Richard Dangler says, is it possible that Monica consumed Ron's chin? Yes. Maybe likely. Viden the Cold One says, I'm glad I like subs. This has ruined dubs for me. Very unfortunate. 2012 Jameson says, Weber versus Fernandez case. Tell Ty about it. It's a Fort Worth case that talks about mistakes in criminal language and falsely accusing someone of a crime. Skaki Onsai says, Urban Dictionary, Ronversation. Look it plus the date up. Here we go. Here it is, guys. So there's an Urban Dictionary entry for Ronversation. March 6, 2009? No! What? An utterly pointless and awkward conversation that draws on for an intolerably long time, usually with someone who, despite your best efforts, does not realize you do not want to talk to him. Man, that just went on and on. He was just insisting on having a Ronversation with me. Oh, someone else has been subject to Ron Toye. No. Oh my gosh. By the way, oh, here we are. We are up to $277,345. Let's get some thank yous. I think thank yous are in order. We've got Nathan Phillips, Daniel Aho, Yusuf Chaudhry, Adam Stinnett, Joseph Cole, and Gina Buck. Thank you guys for your very generous donations. Of course, you know, this appeal does keep trugging along, and it is expensive. As you can see, Sam Johnson has charged $37,500, allegedly. At least he's asked for it, for the appeal brief. So you can imagine the pinch that this puts on Vic and his counsel as well. Bad Vibe says, did Sam argue himself into a corner? No, he didn't argue himself into a corner. He just opened the doors, man. Opened the doors to counter arguments that didn't need to be opened, in my opinion. Rogue says, these filings are sounding like Hail Marys more. We'll see. Well, that's it, guys. Thanks for hanging out for the show. Like I said, we will be over on Twitch in a few minutes. I gotta go grab that snack, and we will have to do this another time. Let me get that outro music playing for you. We will have another show tomorrow. Keep an eye out. Look for another video on the alternative channel very soon. I've got a lot. Look. I mean, well, I guess you can't really see based on where you are, but there are a lot of books on this shelf to be reviewed. There's a lot of other things to be reviewed as well. It's not just a Warhammer channel. That's just a lot of the nerd stuff that I've got. It's, you know, I'm going to just be talking about anything that I like that I have over there. That is at all media related. It is not a legal channel. The legal stuff will stay here. So, all right, guys. Thanks for hanging out tonight. Hope you have a good night. We'll see you over on Twitch. Peace. Peace.
Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an odd bag of bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all planet folk, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what